Legal Hotline Q&A. In the previous section, we focused on the real estate broker's disclosure duties and learned that brokers must act with reasonable care, loyalty, and full disclosure when representing clients in a transaction. That discussion naturally leads into one of the most practical parts of this course: the real-world questions that come up during transactions when buyers, sellers, and brokers are trying to decide who must disclose what, who must investigate what, and how far a licensee's duty extends. This section brings those issues together in a legal hotline Q&A format. The goal is to show how disclosure rules apply in everyday practice, not just in theory. In Arizona real estate transactions, disclosure is not a one-way street. Sellers have important obligations, brokers have fiduciary and regulatory duties, and buyers also have responsibilities that cannot be ignored. One of the most common misunderstandings in real estate is the belief that the buyer is simply a passive recipient of information. That is not the case. A buyer must act in good faith and deal fairly with the seller. A buyer must also inspect, investigate, and verify important facts about the property before closing. At the same time, the broker must help the client understand where the broker's role ends and where the expertise of inspectors, surveyors, attorneys, roofers, contractors, lenders, and other professionals begins. This section also highlights how Arizona law, the AAC R428-1101 Professional Conduct Rules, ADRI Substantive Policy Statement 2005-13, and more recent clarification regarding AAC R428-701 Compensation Sharing Disclosure Timing, all fit together in modern brokerage practice. These rules help explain what a reasonably prudent Arizona licensee should do when communicating information, recommending due diligence, and documenting important disclosures. A home buyer's responsibility to disclose, inspect, and investigate. A great deal of attention is often placed on the seller's duty to disclose, and for good reason. However, a buyer also has legal and practical responsibilities in the transaction. A buyer cannot simply assume that every important fact will be discovered and explained by someone else. Buying a home is a major financial decision, and Arizona contracts and practice standards expect buyers to participate actively in the due diligence process. A buyer must act in good faith and deal fairly with the seller. This means a buyer cannot present himself or herself as a ready, willing, and able buyer if the buyer knows there is a serious risk that he or she will be unable to perform. If a buyer knows of a fact that could materially affect the buyer's ability to close escrow, that fact should be disclosed. This responsibility is also reflected in the Arizona Association of Realtors' Residential Resale Purchase Contract, where the buyer represents that important information affecting the buyer's ability to close has been disclosed. In practical terms, this means that if a buyer's ability to purchase depends on selling another home, obtaining financing under certain terms, or receiving funds from another source, those facts may need to be disclosed so the seller can properly evaluate the offer. For example, if a buyer submits an offer that appears strong on paper, but the buyer already knows that loan approval is uncertain because income documentation is incomplete or credit issues remain unresolved, the buyer should not remain silent and allow the seller to assume the transaction is secure. Fair dealing requires honesty about material performance risks. When financing is involved, one of the most helpful tools is a conditional loan approval letter from a reputable lender. Ideally, the buyer should obtain this before submitting an offer. The letter helps identify financing conditions and can provide important information to the seller about the buyer's ability to perform. If other facts could prevent the buyer from closing, such as the need to first sell another residence, those issues should also be disclosed. A buyer also has a responsibility to inspect and investigate the home. Arizona contracts typically provide an inspection period, commonly 10 days unless the parties agree otherwise, during which the buyer can conduct inspections, investigations, and due diligence. This period is one of the most important risk management tools in the transaction. During the inspection period, if the buyer reasonably disapproves of any aspect of the property, the buyer must provide the seller with written notice identifying the items disapproved and stating whether the buyer elects to cancel the contract or give the seller an opportunity to correct the issue. This is not a time for vague complaints. The buyer should clearly state what is wrong and what remedy is being requested. For example, if termites are discovered, the buyer should be clear about whether spot treatment, full treatment, or additional repairs are being requested. If a roofing issue is discovered, the buyer should indicate whether patching is acceptable or whether replacement is required. The more specific the request, the less confusion there will be later in the transaction. The buyer's due diligence responsibilities go beyond physical inspections. Buyers should investigate building issues, zoning, fire and safety matters, utility concerns, insurance availability, title matters, and community restrictions. Buyers should review the title report, CC&Rs, association documents, and any other materials that may affect the buyer's intended use of the property. If the buyer has special concerns, such as short-term rental use, home-based business use, future additions, solar transfer issues, or pool compliance, those concerns should be investigated before closing. In other words, the transaction works best when disclosure and due diligence are treated as a shared process. Sellers disclose what they know, brokers communicate material facts and recommend verification where appropriate, and buyers take an active role in investigating the property they intend to purchase. Broker duties. When clients need more than a broker can give. As we discussed in the last section, a broker's duties arise from fiduciary obligations imposed by common law and from Arizona's professional conduct rules. Cases such as Jennings v. Lee, 105 Arizar 167, 461 P2 161, 1969, and Morley v. J. Padgel Realty and Insurance, 27 Arizars App. 62, 550 P2D, 1104, 1976, make clear that a broker must disclose material information and help the client understand risks that could affect the transaction. But one of the biggest questions in practice is this: does a broker have to independently verify every statement made by a seller, buyer, lender, or third party? Arizona law does not impose that kind of unlimited duty. Instead, the broker must exercise reasonable care. The controlling rule is found in AAC R428-1101I, which provides that a salesperson or broker must exercise reasonable care in obtaining information material to the client's interests, accurately communicating that information to the client, and taking reasonable steps to assist the client in confirming the accuracy of information relevant to the transaction. The rule also makes clear that a broker is not required to have expertise in subject areas outside the scope of the real estate license. That point is reinforced by ADRI Substantive Policy Statement 2005.13, which explains that reasonable care may include recommending that a client seek professional or technical advice when the issue is beyond the expertise of the agent. This policy reflects the practical reality of the business. A real estate licensee is not expected to be a home inspector, roofer, engineer, surveyor, attorney, appraiser, or tax professional. For example, if a seller states that the roof is in great condition and there is nothing visible suggesting otherwise, the broker may generally pass that information along without becoming a roofing expert. However, if the broker sees obvious water stains, broken shingles, sagging materials, or other suspicious conditions, the situation changes. At that point, a reasonably prudent broker should point out the concern, recommend further investigation, and document that recommendation. The same is true when a client expresses doubt about information received during the transaction. If a buyer says, "I'm not sure this lot line is correct," or "I do not trust what I'm being told about the solar lease," the broker should not guess. The broker should help the client get verification from the appropriate source. This approach is also consistent with the National Association of Realtors (R) Code of Ethics, Article 2, which requires realtors (R) to avoid exaggeration, misrepresentation, and concealment of pertinent facts, while also recognizing that realtors (R) are not required to discover latent defects or advise on matters beyond the scope of their real estate license. Solar lease. Questions and liability reduction. One issue that has become increasingly common in Arizona transactions is the presence of leased solar systems. Solar panels may add appeal to a property, but a leased solar system can also create confusion and delay if the parties do not properly address it early in the transaction. A leased solar system raises several important questions. Is the system owned or leased? Is the lease transferable? Does the buyer qualify to assume the lease? What are the monthly payments, escalation terms, maintenance obligations, early termination provisions, and credit requirements? A buyer who is excited about the home itself may become less enthusiastic if the solar lease creates an unexpected long-term financial obligation. That is why disclosure and due diligence are both essential. The seller should disclose whether the system is leased rather than owned and should provide the buyer with enough information to understand the arrangement. The buyer, in turn, should investigate the lease terms before the end of the inspection period. A practical risk management step is to attach a copy of the solar lease to the SPDS when the property includes a leased solar system. The SPDS addresses alternate power systems and gives the seller a place to identify the leasing company and provide additional information. When the lease is attached, the parties are in a much stronger position because the buyer has direct access to the terms instead of relying on assumptions or incomplete oral explanations. This simple step can significantly reduce liability. If the buyer receives the lease and later decides to proceed, it becomes much harder for that buyer to argue that the seller or broker concealed the existence or terms of the obligation. At the same time, attaching the lease helps the buyer conduct proper due diligence and make a better informed decision. ADRE clarification on compensation disclosure. Another topic that caused confusion in practice involves AAC R428701, the Arizona rule addressing compensation sharing disclosure. Under the updated rule, a real estate broker must disclose to all parties in writing, at least 3 calendar days before closing, the name of each employing broker who represents a party to the transaction and who will receive compensation from the transaction. This timing clarification was part of the recent ADRE rule modernization process. October. Rule changes. An important clarification is that the rule does not require disclosure of the amount of compensation to the opposing party. The disclosure requirement focuses on identifying the employing brokers who represent parties and who will be paid from the transaction, not on revealing the exact compensation amount to the other side. In many transactions, this disclosure is already effectively handled because the brokers are identified in the purchase contract. However, when an employing broker who will receive compensation is not clearly identified in the contract, separate disclosure should be made to all parties no later than 3 calendar days before closing. This is a good example of why brokers must stay current on rule changes. Small wording changes in the administrative code can create major confusion if licensees rely on old habits instead of current law and guidance. ADRE rules, policy statements, and everyday practice. The Arizona Department of Real Estate has authority to adopt administrative rules, often called commissioner's rules, and to issue substantive policy statements explaining how the department interprets statutes, rules, and case law. Administrative rules are adopted through Arizona's formal rulemaking process, while substantive policy statements are advisory expressions of the department's current interpretation. A rule such as AAC R4-28-1101I has direct regulatory importance because it sets the standard for reasonable care in obtaining and communicating material information to the client. A policy statement such as SPS 2005 13 helps explain how ADRE expects licensees to apply that standard in the real world. Together, these authorities tell Arizona brokers to do 3 important things. First, accurately communicate material information. Second, recognize when information should be questioned or verified. Third, recommend qualified professional assistance when the matter goes beyond the broker's expertise. A helpful way to think about this is that brokers are expected to be good traffic directors. They must recognize when an issue matters, communicate that to the client, and direct the client to the right professional resource. A broker who tries to act like an inspector, engineer, attorney, and solar contract analyst all at once is likely creating risk, not reducing it. The safest practice is to disclose what is known, identify concerns when they appear, recommend professional review when necessary, and document all important communications in writing. Online discussion. Why is the buyer's duty to inspect and investigate just as important as the seller's duty to disclose? Answer. The buyer's duty is important because the seller may not know every condition affecting the property, and the buyer must decide whether the property is suitable for the buyer's intended use. Inspections and investigations help the buyer verify information, uncover concerns, and make an informed decision before closing. Why does Arizona law expect brokers to recommend outside professionals instead of answering every technical question themselves? Answer. Arizona law recognizes that brokers are real estate professionals, not experts in every technical discipline. When a matter involves roofing, engineering, legal interpretation, solar contract terms, or other specialized issues, the broker is expected to use reasonable care by recommending the appropriate expert rather than guessing. Why is attaching a solar lease to the SPDS such an effective risk management step? Answer. Attaching the solar lease gives the buyer direct access to the lease terms and helps prevent later claims that important information was hidden. It supports seller disclosure, encourages buyer due diligence, and reduces misunderstandings about payment obligations, transfer terms, and other lease conditions.